cornerstones for any nation to be successful. That is actually, I feel, from this is my own perspective, that is actually, first is transparency. The second one is the trust. And the third one, these are all three T's. The three T's, the cornerstones. And the third T is technology. And today, we are in a digital world. Actually, the previous speaker was mentioning about, even in Sri Lanka, the technology and the digitization is there very visibly, from use of credit cards to cell phones, then the documentation, all that, today you have to have the technology, and technology means in a digital world, and that's what the ISACA philosophy is enabling, digital trust. So in such a context, the data privacy and protection is so important. So New Zealand has been in the forefront for a pretty long time. So let's move on to the next slide. So before we go, let me give you some to get the context. What is happening with regard to the data breach? Because in a volatile, uncertain world, there are people who want to make money in various ways. The easiest way, rather than robbing and physically robbing and doing all other criminal activity, there are another type of criminal who wants to take people's valuable data and use it for commercial purposes. So that is why these data privacy laws have come into effect. So this is actually from the IBM Security Report 2020. See, there are 524 organizations have been breached, and that means 17 countries, and total cost of $3.86 US in millions. The biggest vulnerable industry is healthcare industry. Many of you would have thought it is finance or banks, but no, healthcare industry, because there you have a lot of valuable patient data. So and they have found that average time to identify and contain that damage is 280. That means some organizations have taken much more time to identify, detect, and then contain. So GDPR and every country has taken it very seriously, and Sri Lanka in 2022 has come up with this Data Protection Act, and which is very, very timely, and it is important. Actually, Tanushi mentioned about why it is important. Actually, I can add, is not only protection of people's data, but as a country itself, to present as a country where there is good systems in place to protect, preserve personal data. So the various authorities have put heavy fines on organizations who have been negligent, who have not been following what they should do to protect people's valuable data. So data or information. Data, when it is properly structured and arranged, it becomes information. So the biggest was up to date was Equifax. Equifax is a company which collects personal credit data and for various banking and other services. So they have been fine. They had a loss of 1.4 billion US dollars. It's huge. Then you must be remembering that about 2 years back, British Airways, for not reporting loss of customer data by credit card skimmers, they were fined 230 million US. Uber, failing to report the loss of customer data, 148 million. So what they did was they bribed, they paid, they found who had been stealing, they paid that party 10,000 US to hide that, but it was detected and they were heavily fined. Google was another, there are so many organizations, and Google was fined also a hefty amount. So we move to the next slide. Next slide. Can we go to the next slide, please? Can you hear me? Oh, yeah. That's right. Actually, there was a slide you have missed. Can we go back? Actually, there was a territorial, yeah, just before that. That's right. Yeah, so this is the territorial map. So we are going to talk about the New Zealand, and also we look at what Australia and Singapore has done. But there's a vast difference when you look at Australia. Australia is a huge place, but unlike New Zealand or Sri Lanka, which is a one country, but Australia has various internal territories: Western Australia, South Australia, Northern Australia, Queensland, New South Wales, where Sydney is, and then Victoria and Tasmania. So each one has slightly, they have a overall, corporate like data privacy law, but each state has adopted their own data privacy requirements. Okay, let's now move over to the yeah, that's right. So this is actually, I just thought it's good to look at the progression over the years with regard to New Zealand. Actually, our focus that you saw, the red circle, focus was is on New Zealand. So actually, New Zealand is one of the first countries in the world, one of the first countries, I will repeat it, in the world to have thought about protection of individual data. In 1993, it became one of the first countries in the world to adopt privacy regulation as per OECD guidelines. See, before even Australia, before even US. So they are quite smart in that. So in 1995, the OECD guidelines were reviewed, and in 2001, Australia applies for adequacy decision by the European Commission so that there can be exchange of data between two countries for data processing for various, commercial activity, and it was rejected. In 2003, New Zealand applied and it was accepted. So you see the difference, because we have a reasonable history and there have been good governance in protecting people's personal information. So another milestone in the whole journey is the 2018 coming up of the EU GDPR, Global General Data Protection Requirement of the European Union. And in New Zealand was working on it. They were improving the Privacy Act, and in 2020, 2 years back, it was on 1st of December. The act was passed in the Parliament with all new requirements and additions in line, very much in line with GDPR. But there were some which were a little different. We will talk about it. Let's move to the next slide. So New Zealand data privacy is actually how organizations and businesses, we were talking about it all this time, collect, store, use, and share individual information. Today, it's a digital world, and everywhere, everything is digitized, from e-learning, because even registering something, going into the supermarket, buying things, everything there is digital involvement. And unless we have the road rules, see, the whole thing is having good road rules gives confidence. If you don't have good road rules, there will be chaos, there's accidents. So that's why with the countries where there are good road rules, good discipline, good governance, there is confidence, not only within, but outside. So if, especially in Sri Lanka, if Sri Lanka wants to attract foreign business to do data processing, you are talking about data controllers and data processing, and now a lot of countries are outsourcing because it is cheaper for them to pass it over to another country where they do it at a lower cost. So if the road rules are there, if the house is in order, so that builds confidence. That's why I said that a country to develop, there should be a transparency and trust. So you have good practices, good governance, and then there is no doubt that things will happen the way it should happen. We'll move to the next slide. So the New Zealand Data Privacy Act 2020, as I mentioned, it was passed on 1st of December. We have 13 principles. I'm not going to go into details because I'm having a very limited time. So from actually, these are very common thing. It's a lot of overlap between GDPR, but they did not do any copy and paste, but they really discuss, and a lot of experts were brought in, and they had various discussions, and came up with this 13 principles, it's called. So from why you collect data, and also very important to remember that New Zealand has given emphasis to human relations rather than privacy. The importance is human, because this country gives very, very sort of consideration and importance to the human being itself. So your data is stolen, your data is taken and used for some other purpose rather than what is intended. So that is considered as criminal. So that's why these 13 principles cover all that, from collection of data, use of data, and the ability, if my data I have consented, okay, but 2 weeks later I realized that it was not 100% accurate, so I should have the privilege to correct that data. I have to tell them, and they should immediately, not take weeks or months or years, but they should do it instantaneously, correct my personal information and ensure accuracy before it is being used for whatever the purposes. Then that's why the emphasis here, you can see the shade of human relations. That is the most important thing. And of course, the overall, I can tell that they should not use it for commercial purposes. And also they have very strict procedures for using the personal data outside the country. So they can use it, but they had to have it. So if my business wants to have some relationship with another country, and if it is based in EU, it is more or less, at least there is no hindrance. But if I want to do some business and I am sending the personal information data of some of my customers for processing or whatever it is, then it can be a violation of the New Zealand Privacy Act. We'll move to the next one. So also it has given a lot of powers to the Privacy Commissioner. So the person in charge of the Privacy Act implementation and management is the Privacy Commissioner. Actually, he has the ability to what you call issue a code of practice to have specific rules for these areas like civil defense, credit reporting, privacy code. These are code of practices. Health information. This is very, very important. A lot of restrictions. Sharing is very, very controlled. Then justice sector, people's names, the prisoners and all that. The people cannot, to take it or use it, they need a lot of filtering. And then, of course, superannuation, that is the retirement, and telecommunication information privacy code. So there are 6 code of practices issued by the Privacy Commissioner. So this is something different. You don't see that in Australia or Singapore. So we are looking in relation to Australia and Singapore. Let's move to the next slide. So New Zealand Privacy Act, key features are, everybody can see the slide, right? So requirement to report privacy breaches, this is like in GDPR, it is sort of common sense for privacy regulation. Then compliance notices. The commissioner can issue compliance notice to comply with the privacy code if any company was found violating. Immediately, you can ask for reasons, and if they cannot provide that, they can be, have a lawsuit. So, also the data owner should have the ability to access the data if it is necessary, and if there is a problem, it can go to the Privacy Commissioner. Then also the cross-border protection. New Zealand agencies will have to, this I mentioned, to take reasonable care and steps to ensure that personal information and sent overseas is protected by acceptable privacy standards. So that has to be compliant, and it should be visible. It should be auditable that such things have happened. So these are some of the highlights of this New Zealand Privacy Act. So the whole thing is to ensure, again, to protect the people. So then there's another one, new criminal offences. So it will be an offence to mislead an organization in the way that it affects someone else's personal information. So actually, you have to be very transparent and very clear and precise for what purpose it to be used and how it is going to be stored. The other one is if there is a breach, it has to be notified to the Privacy Commissioner. Now, here there is a difference. Difference is New Zealand has put a very low penalty. New Zealand dollars, 10,000. Actually, people are talking about it. They feel that it is insufficient. I'm not sure how much Sri Lanka has the penalty, but GDPR has 2.1 million, if I'm not mistaken. So in comparison, this is far, far too low. So one of the differences. Okay, let's move to the next slide. I think I have got only 5 minutes more to finish it. So the other one is the last point is extraterritoriality that is going overseas when treated as carrying on business in New Zealand. If somebody takes the data and use it overseas, it is like carrying on business in New Zealand. So they had to again take all the necessary controls in place and take the precautions. Right. Let's move to the next one. So then we'll look at Australian Privacy Act, 1998, and of course, this is the they had this act in 1998, and then it had gone into a lot of time to time improvements and modification. So there's a continual improvement. So its main purpose is to promote and protect privacy of individuals and regulate the Australian governments and organizations with over, they have not everything, with over 3 million Australian dollars, and how they handle their people's information. So the other thing is actually they have also got much heavier penalties. We will be looking at it. Let's move to the next one. So I have just put some key areas of penalty. See, New Zealand, the penalty for non-reporting or breaching is 10,000. In Australia, it is 2.1 million Australian dollars, New Zealand dollars. And in GDPR, again, 20 million euros or 4% of the annual turnover of that company, whichever is higher. You see, the comparison is something totally out of sync. Then applicability applies to all public and private agencies. Now, I mentioned that in Australia, it applies to those agencies which are more than having turnover more than Australian dollars 3 million. So there's a difference there. I'm looking at the difference. And all with regard to GDPR, all EU agencies which determine the purpose and means of processing data, if they are doing that, they are covered. Any organization which process data. Actually, practically every organization will fall into it. Because they are always there. Today is a digital world, I told you. Then jurisdiction and borders in all New Zealand agencies and overseas agencies collecting and holding data of New Zealander are coming under this. So it doesn't matter where, even if it is in Sri Lanka, the law applies if it is being done there. If it is done in India, the law applies. So then they have to take all that what is mentioned in the New Zealand Privacy Act. Then in Australia, all the agencies incorporated in Australia and those who collect and hold Australian citizens' data are covered. It can be in Japan or anywhere, but if they are holding Australian citizens' data, they are coming under that. So the problem is they have to really comply, and violation will get into heavy penalties. With regard to GDPR, it had to be in EU or offer goods and services to EU individuals or monitor EU individuals from any part of the world. You see, so there is a big territorial coverage. It can be any country. If they are serving EU citizens or anybody residing, not only citizen, anybody residing there, they have to comply with the GDPR. So we'll move to the next one. To go a little fast. Then Singapore, they have I think Peter is from Singapore. He will be presenting more about this. They have the Personal Data Protection Act. It's called PDPA. So in 2012, the law was passed and went into different phases, like in most countries, from 2013 to 2014, to uplift that and incorporate more requirements in line with the global standards or good practices. So PDPA, that is what you call Personal Data Protection Act, doesn't cover government agencies and organizations. So that is a difference. And also in 2020, the PDPA was amended to add data breach notification. So earlier it was not there. So now they have specified a time, and not complying will lead into serious fines. So also they have the right to portability and stronger enforcement of powers to the authorities. So we'll move to the next one. So how to comply with PDPA? That is in Singapore. At high level, there are specific, that is what is important. If anyone is going to do open a business or have some business transactions with Singapore. So this is where had to be very mindful. Only collect data for purpose to which the user has consented. That is there in every country. Only use or disclose the personal data about the individual for which they have concern, not anybody else, only with the individual concern. Notify individual the purpose behind the collection, why you are collecting, use or disclose of data or before it is collected, why it is collected, and how they are processing, and all that full process has to be transparent. Provide individual with information about the ways the personal data has been used, what is collected, and make reasonable effort to ensure that personal data is accurate. They had to take, of course, somebody can make mistake, but you have to take all measures to ensure that it is accurate. We'll move to the next one. There is some more. And so ensure that the personal data is protected by taking the right security measures to prevent unauthorized access. So that is a common thing everywhere it is happening. So the other one is discontinue storage of personal data and remove the ability for the personal data to be associated with an individual when it no longer serves the legal purpose for which it was collected. One is the purpose why it was collected. If it doesn't happen, then you have to discontinue and inform the data subject, the person. The other thing is that also they have, if the person is dead, all right, then of course again they have to take proper action to inform the next of kin. The only transfer of personal data across borders to other countries according to the requirements of the regulation. So that is same thing like in GDPR, and make data protection policies, complaints process, and security practices available when the user requests them. So if the user, the data subject wants any one of those things, it should be transparent. It should be readily available. It should be instantaneous. Today with digital enablement, this should be instantaneous. Let's move to the other slide. So this is the wrap up. I think I'm okay with the time. So as I said at the beginning, technology, transparency, and trust are the cornerstones. And it is essential for any nation's prosperity in today's country. Today is a digital world. You cannot think of anything. It is a digital world everywhere. So data protection plays a major role in that journey. So if you are, like I said, road rules are so important. privacy and data protection is a human right. Earlier it was not thought of. Now it is my right, my data, who collects it. It doesn't matter where and for what purpose, but they should ensure that it is totally protected and secured. So, and also used for purpose for what it was collected. New Zealand, Australia, Singapore have strict rules in line with the EU GDPR. So if you have good governance, so people will come into your country and they will do accurate data processing. It can be, with the digitization, the physical boundaries, geographical boundaries are becoming loose. People should be able to move here and there. So today people go from one country to another country. Maybe they can come to, some people might come for holidays to Sri Lanka and spend, not holidays, actually working holidays. What do you call that? Digital nomads. They go and they work in those countries, India, Maldives, Philippines. They go and work and they pass, they communicate, they process data and do various things. It's a data world. And if these protection measures are there and road rules are there, that gives total trust and confidence. This is the one T: trust, confidence. And laws and regulation should be applied and executed in the same spirit. You may have laws, you may have all these things passed in the parliament, and that it is of no use unless it is executed in the same spirit that they were being created. So I think that is the last slide. Can you move to the next one? So these are my contact details. I believe this slide pack will be available, and you can contact me. I'm sorry that we had small hiccup at the start, but we were able to manage. Thank you so much.
Thank you, Mr. Vijay Tilakam, for that very insightful presentation. Next, we have a presentation by Mr. Deepak. He will be speaking on governing and program management for privacy for enterprises. Mr. Deepak is a director for cybersecurity services at Deloitte India. He is an experienced information and cybersecurity professional with over 2 decades of experience. He holds a bachelor's and a master of science in computer science from the University of Madras. Apart from that, he also holds numerous credentials, including CISA, CISSP, and so forth. So without further ado, let me hand over the controls to Mr. Deepak to do the session.
Thank you. Hope you're able to hear me clearly.
Yes, Deepak.
Okay. Thank you. First of all, I would like to thank ISACA Sri Lanka chapter for having me here amidst this gathering to discuss on the topic governing and program management for privacy for enterprise. So this is what I'm planning to cover as part of the agenda of the discussion. So we'll start off with introduction to privacy program management and governance. Recommendation on privacy governance and controls for enterprise. What are the key benefits of privacy governance? Steps to program management for privacy. What should be a privacy team structure in an organization? And what is the road to privacy maturity? Right. Okay. What is program management and governance, right? It is not very specific, or this particular subject is not very specific to privacy only. It should be imbibed in all aspects of our life. Say, for example, I'm building a house now, right? And I have outsourced to a contractor. but the amount of governance and program management that is required to build a house, that is like coordinating with the local authorities, the municipal authorities, getting the permits, identifying the raw materials, the best in class raw materials, identifying the workers who can help us in building the house, whether they are skilled, whether they are not skilled, and also putting in a plan on the timeline, agreeing the timeline with the contractor, etc., right? It takes so much of governance and program management to even build a house, okay, which is our individual activity. It is not for an enterprise. But considering you are implementing a privacy program in an enterprise, which requires implementing the entire framework in line with the requirement of the law, and also which involves a lot of cultural change that is required in an organization, where privacy culture has to be imbibed within the organization, is not an easy task. That is why the importance of privacy, governance, and program management comes into place, right? Why are those required? So let's see some of the points. Increase regulation. Now, the act is there for Sri Lanka. There will be multiple jurisdictions of privacy regulations. You have to consult a lot of legal, you have to actually consider a lot of legal ramifications, legal inputs that is required to comply with that law. Your branding and risk. Okay, so what happens if you don't have a proper privacy framework in place, on all the controls in place? What is the impact that you will have from your brand perspective as an enterprise? Customer sensitivity. With the rights given to the individuals on privacy by the law, there's a lot of customer sensitivity that comes into place. You have to understand how the data of your personally identifiable information of the subject can be used, can be, you have to get the consent, you have to give them the right to forget, you have to give them the right to erase, you have to give them the right to modify, you have to give them the right to transport. All those rights comes with the law. And your framework or the controls that you implement should also include all these things. Globalization, consider your enterprise moving to other markets globally, right? As this eminent speaker before me mentioned, there are a lot of privacy laws across the world which needs to be followed when you are operating in their respective markets. Okay, how are you going to include all their requirements in your respective privacy framework that you are going to implement in the enterprise? Advances in the technology. Now the world is going digital, right? When we are going digital, that means that whatever information that you have is accessible across the world. That is one of the major drivers for going digital. And you have to ensure that all the requirements of privacy, all the requirements of the law related to privacy are taken care when you are going to through digital. It also includes the use of personalization technologies like cookies, smart tags, unique identifier, your profile, whatever you have in that particular application or the digitization that you're doing, and extended enterprise, right? When you are growing big for big enterprises, there's a lot of dependencies on the third parties, okay, vendors, partners, service providers, etc. So it is not only the activities that is done by your enterprise that needs to be taken care of, but also the activities done. You are accountable for the activities that you have outsourced to the third parties as well. So you need to actually take care of those aspects with related to privacy when you are outsourcing the activities to the third parties. The speakers before me have listed on some of the aspects that needs to be taken care of. So all these things should be taken care of. That means that you need to have a proper governance. You need to know what you are going to do when you're implementing a framework. How are you going to do, and when are you going to do? All these questions are answered only when you have a proper and a strong governance setup, and also a proper project planning when you are implementing a privacy framework. Right. So I'm just going to, at a high level, talk to you about what are all the privacy governance and controls that you need to implement for an enterprise. First one is you have to set up the privacy governance. Okay, so when we all started on the ISMS journey, and way back in 2000s when the standard was still BS 7799. security governance at that point in time was not understood well by many of the organizations. Okay, while we had a setup of having a steering committee and all those stuff, but it was done for a certification purpose, or it was done for taking some approvals, etc. But as in these 20 years, when the information security management system got matured, the importance of governance or the management or the leadership or the board of many of the enterprises started to understand the importance of having a strong governance of information security. Because in these 20 years, it is not only the ISMS which got matured, but also the loss of the land caught up, right? And there are a lot of regulations that are coming in various countries, where starting from especially in regulated markets like financial services, manufacturing, etc., where critical infrastructure is implemented, where it is required by the law for having a strong ISMS implementation, governance, reporting the security incidents, the timeline for reporting security incidents, and all those stuff. So when the organization started to actually analyze how to comply with this framework, they finally realized the importance of having a strong governance, and also the commitment from the board level leadership, okay, on driving this entire governance. Okay, a strong privacy governance requires a formal corporate governance structure. It requires a proper privacy framework that needs to be set up, and the roles and responsibilities of each individual, starting from the board until the new entrant or an employee or a contractor, whatever, has to be very clearly defined. Right. Next, data collection and permission. I'll not dwell too much into it. It is about the subject rights. What is the type of data that you collect, and whether you have the consent from the subject to collect. You have to put in technical solutions. You have to put in processes, controls, policies, everything to govern this particular thing. Data confidentiality and assurance. Data governance and education. There's a difference between a privacy governance and a data governance. From a data governance perspective, you need to understand the entire life cycle of the data, from the time that data is created, how it is used, how it is transferred, how it is stored, how it is deleted, okay, including the retention. At each stage of the data life cycle, what are the controls that you have? What is the governance that you have? Do you have the data custodian in place? Do you have the data owner in place? Whether all the access to the data is approved and by the respective data owners and the custodians. All these things should be put in place, including the technology required for data protection like DLPs, encryption, etc. All these things come under the data governance framework. Privacy compliance monitoring and framework. It is not only implementing a framework that is important, but the sustenance of the entire framework on your day-to-day activities. How are you monitoring the compliance? How are you running the entire privacy program framework that you have implemented is also really important, that needs to be implemented as part of your policy governance. Privacy incident response plan. Yes, that is very, very important, specifically when a lot of fines are involved. You have seen these slides from the previous speaker, and what is the amount of money that you have to pay to the government if at all there is a breach or you have identified a breach. Okay, that means that your incident response should be very well defined, and it should be very well tested also. Okay, because you have 72 hours or 24 hours or whatever it is, depending on the country you operate, to respond to an incident or inform the regulator. So that means that you have to involve everybody in the organization life cycle to make that decision, right? That means that you have to have a strong incident response plan, and you have to test it frequently so that your call tree is in place, your decision makers are attending your calls, and all the stuff are happening. Data flow map. This is also very important for any data that you collect or any application that you develop. You need to have a data flow map so that you understand where your data lies at any point in time. And technology supporting privacy. Any technology that you implement to safeguard your the privacy, you have to ensure that it is fully evaluated, and the technology is also secured before deployment. So these are some of the controls, if not all the controls, that you need to, are very important controls that you need to consider when you are setting up your framework and you are governing the framework. What are the key benefits of privacy governance, right? the key benefit of having a strong privacy governance and the project management is to actually minimize the impact that the lapse in control or lapse in having a very Medicore privacy framework will bring it, right? With a lot of regulations that are coming in place and the laws coming in place. Okay, so you will mitigate a lot of risks to the organization, such as possible damage to your organization's public image and reputation, potential financial and operational losses, regulatory sanctions, fines, loss of customers' data and trust, right? Ultimately, everybody does business and the customer is very important. If a customer loses trust in our business, then it is a business loss for us, and it leads to, it's a rippling effect it will have in many other aspects of your organization. Okay, and you will also end up in damaging business relationship, right? It is very paramount for an organization to implement a effective privacy program and governance, good governance, to ensure that all your risks are identified with related to privacy. It is you are putting in controls in place to mitigate those risks, and you also monitor the entire landscape or the entire framework, so that you will be easily able to identify the new risks that are coming in, any changes that are required based on law, based on your a new business venture that you're getting into, etc., are taken care of, and it is done as per the policy that you have framed and as per the requirement of the law. Okay. And again, privacy, implementation of privacy, the governance and maintaining it, it is not only the responsibility of the privacy or the DPO or the privacy team that you have in your enterprise, right? It is a multidisciplinary effort. Okay, it is not, it cannot be done only by the people whom you have hired or whom you have appointed for privacy, right? So it involves technical, organizational, and legal aspects. See, all these three things have to be involved for you to have an effective privacy governance. Okay, why legal? Now, privacy is an act. It is required by the regulations. And as a privacy expert, I'm not a legal guy. I cannot interpret all the requirements of the act and give you a legal guidelines, right? It can be done only by a qualified legal professional who has experience, who has the understanding of the legal framework of the country, who has the understanding of the constitution of the country, and who can translate those legal requirements in the easy terms or easy language where we all can understand, right? So having a strong legal guidance for a privacy program is really important. Okay, so that it is not only helpful in implementing the current act that you have in place, but it will also help in if there are any changes in the legal landscape or the legal landscape of the law, as well as you require a lot of legal interventions when there is a security breach and you are reporting to the respective DPOs of the country. Right, everything has to go through legal, everything has to be signed off from the legal, so that you are protected from a lot of impact that it might happen later. Organizational. Okay, organizational means the rest of the world within your enterprise, right? So it might be your business owners, it might be your data owners, it might be a board, it might be your information security team, it might be your vendors. Okay, all these organization within your enterprise have to come together, okay, and provide you with their requirement, provide you with their support, and provide you with their inputs, okay, for your governance and framework to be very effective. Okay, and then technical, right? It is a very important aspect of privacy, right? Technical is like, say for example, we all have our own private certificates, right? Say, for example, your college degree or your bank passbook, whatever it is, which contains your personal information. Okay, but to safeguard it, you put it inside a locker or a drawer or a key and close it, right? Only then your private information will be secure. without implementing technical security, you cannot achieve the entire privacy compliance, right? You cannot safeguard your privacy. So that is very paramount. So your entire IT security team, your DLP team, your firewalls, everything, your encryption, everything comes into place when you are implementing a privacy program in your organization. So these three are the major disciplines that you have to consider when you are implementing a privacy governance in your organization. And all these three domains should be part of your privacy governance, right? It is very important that you involve all these three domains in your privacy governance so that the governance will be effective. Okay, and to have an effective governance, a management should understand and also provide knowledgeable people of with the privacy knowledge in the organization, right? So it is a very niche field. Privacy, understanding the requirements of privacy is very niche. So you require knowledgeable people who can implement, who can run, who can govern, who can sustain your privacy program, right? And it also needs to understand and cognizant and be cognizant of the fact that enormous technical aspects are required for putting a privacy program in place. Okay, and it is very much important the board, the leadership, the management understands that implementing a privacy program in an organization is actually a cultural change. Okay, in this part of the world that we live in, privacy is not something that is imbibed in our culture. Okay, we are more than happy to talk about our personal life. We are more than happy to share about our salary details. We are more than happy to share about our wealth, where we live, etc., etc. Right? But when we are bringing in a lot of controls related to privacy, it is actually a culture change. So it is going to be a slow burn process for for enterprises who are going to implement the privacy program. But once it becomes a law, or it's already a law in Sri Lanka. So once it is implemented as a law, when the regulation requires it, then it has to be done in a fast phase within the given timelines of the government. So it is required for the management to understand this aspect and spearhead the culture change within the organization. From a program management for privacy, program management comes within the governance, but I can say that it is a first step, right? First, implant, as I said, implant the culture of privacy by defining your organization's privacy vision, mission statement. Establish privacy, effective, robust privacy processes. Evaluate, okay, for continuous effectiveness, and enhance your response to the privacy issues, right? Any privacy incidents, any privacy issues that you have, it is very important that you give importance to that so that you can learn from those issues, you can learn from those incidents and continuously improve your privacy framework or policies or controls that are required for your framework to run effectively. Privacy team structure. So I have given it differs from enterprise to enterprise. As the eminent speaker before me said, it is still not important that all the organizations should have a DPO. It depends on the amount of data that you are processing, amount of things that you are doing. But at a high level, okay, you need to have a chief privacy officer or a data protection officer as required by the law. You need to have a privacy manager, privacy analysts, and business line privacy leaders. Since privacy is a culture change, the business should understand their privacy and they have to have people with privacy skills, or at least train their people in privacy so that whenever they do the activities, the privacy aspects are taken into consideration, and especially in IT teams where the applications are developed, right? So we have been shouting for 20 years that security by design is required. Security by design is required whenever you are creating an application or whenever you're designing an application. But now we have to start shouting that privacy by design is required. Privacy by design is required. Okay, so that the security and privacy by design is considered, the requirements are gathered, and it is implemented in the design phase itself, because doing a postmortem and going back and redesigning your entire application once the law comes into effect is going to cost a lot of issues, and it is also going to cost a lot of money in re-engineering your entire applications. See, re-engineering a business process can be less costly, but re-engineering an application to support those business process to include those privacy controls is really going to be costly. That's what we have seen. So the organizations have to be cognizant of the fact. And if you are developing a new application, and if you are developing a new whatever activities of business process, embed the privacy requirements in their business process as well as application. And it's very important to define the role of each team member, define the role within the organization of the each team member, provide continuous management support. And if you are across the world, okay, don't concentrate all your privacy professionals within your particular country, but spread the team across so that you get the knowledge of the individual requirements from a regulatory perspective, from the culture perspective, etc., from the individual team across. So this is at a high level how your privacy team should be. And road to privacy maturity. Once you implement any framework, you will not move from maturity level 1.5 to 3.5 once you implement it, right? Anything, it has taken years. Believe me, I've been in this industry for nearly 20 years. It has taken nearly 20 years for our cyber security or information security framework to mature. Okay, the same applies to privacy framework as well. So it will take years for your privacy framework to mature. So what you need to have is a solid structure and pyramid where you always have a good strategy on the top. You define the organization's roles and accountability of the various roles within the organization. You create or you implement the policies, procedures, data management, data transfer, whatever it is. Communication, training, and awareness is of paramount importance, and it is very key for the success of your privacy program. And whatever it is required by the privacy framework, by doing PIA, privacy by design, audit and certification, having ROPA, records of processing activities, all those stuff has to be done in letter and spirit as required by your policies and procedures. So if you have the structure in place, and if you have strong governance and the project management in place with defined roles and responsibilities, with management support and the support from your board and your privacy governance, your privacy framework, and your privacy program will be very successful. With that, I would like to conclude my sessions. And again, thanks a lot, ISACA Sri Lanka, for providing me with the opportunity to discuss these aspects with this August gathering. Thank you, everyone.
Who will be speaking to us about audit and implementing an audit and review framework for privacy and data protection. Soumya is a partner and partner inside the risk services of Deloitte India. She has more than 17 years of experience in IT advisory, operations, risk management, and cyber risk. She's a graduate of St. Edward University and holds an MBA from the University of Texas. She's a certified information privacy technologist and a certified information privacy manager. Ma'am, over to you.
She's muted.
Soumya, I think you are muted.
Thank you. Thanks, everyone. I hope you can hear me. Right. First of all, thank you, ISACA Sri Lanka, for giving me this opportunity to present. I know you guys have had a long day so far, and there have been some really interesting sessions that I've been following. So thanks to all the other presenters also. Today, I'm going to talk a little bit about like the audit and the review framework for privacy and data protection. in line with the requirements for any of the privacy regulations. So I hope you are able to see my screen. Let me start with a brief overview from a perspective of the Sri Lanka Act. Right, as we are all aware, and there have been a lot of discussions, Sri Lanka has been one of the first South Asian countries to enact the Personal Data Protection Act. So kudos to Sri Lanka and the example that it has set for all the other countries in the region. So I know a lot of it has been discussed so far, but I'll keep it very brief. From an accountability and audit perspective, while there is no direct requirement which says that there are audits that need to be conducted, there are a few of the different sections and the offshoots which remains that there needs to be an audit program in place for us to have a robust privacy program. Now, what are those within the Act is one of them, of course, is that there is an accountability requirement that is called out for data controllers, for which we see that a regular audit and a documentation of the same is one of the tools that we have in our arsenal to demonstrate accountability. The second part of it is that there is a call out which says that there needs to be appropriate safeguards, and the fact that the controllers should ensure integrity and confidentiality of personal data. There is also a requirement for the processors to support controllers whenever there is a requirement for a third-party audit. Right, so all these three put together, and given the fact that there is an accountability, there is a fact that that there is a responsibility of the controllers for the data, we see that there needs to be a strong audit program. Now, a little bit to delve a little bit more, there are two things that the program calls out. Well, the first one is not a specific audit; it is an assessment that needs to be put in place. Now, one of them is the privacy or the data protection impact assessments, or the DPIAs. Now, it is made mandatory for 3 parts. Now, whenever there is profiling that is done of personal data or of natural citizens, then we do say that there is a requirement that DPIA is conducted. If there is a systematic monitoring of either, even if it is publicly accessible or like the telecommunication networks, then there is a requirement to have a DPIA to be conducted. And of course, like, any kind of a activity that involves the use of personal or sensitive personal data. So now, when do we conduct the DPIA? The DPIA needs to be conducted in the beginning, whenever you are setting up like either a system or a process or even a business line where the above 3 criteria are met. The DPIA should also be conducted on whenever there is a significant change to any of these, right? So whether it is a system that processes personal data or a business line that does it or a process that does it, then you would have to have a personal data protection impact assessment that is done. Now, this may be used to demonstrate compliance, and the Act does call out to say that the authority, when it is set up, will be able to ask for these DPIAs to demonstrate the compliance, right? Now, some of the things that need to be taken into consideration when you're setting up a DPIA is that you need to have a process in place so that it has automatic triggers. The same as we would have in any kind of a change management, where like maybe like an approval from a change management board, an approval from the business leader is required before your change is processed. You would also have to have similar triggers to have a DPIA that is triggered whenever there is a change or whenever there is an implementation of a process that involves the personal data. You need to have a few other things that need to be there in place, is that templates and risk mitigation steps, and also an exception management policy. So all these 3 needs to be in place whenever you are considering like a end-to-end setup of a DPIA. The next part is like, what are the compliance implications for the processors, right? So while there is no direct law that says that like processors should be audited, there are call outs which says that there needs to be a process or a systematic framework that ensures that the processing activities are carried out now as per the written instruction, which means that the data that is there, the personal data, is being used only for the processes that have been agreed upon between the processor and the controller, right? Now, these will come along with some contractual obligations, which means that there'll be limitations on how the data is used, where the data is used, how it is stored, how it is transferred, and how it is destroyed. In addition, there are, of course, safeguards that are required to maintain both the confidentiality and the integrity of the data, which becomes a processor's responsibility, which is kind of like coming as a part of their contractual obligations. Now, one thing that the Act does call out is that the processor needs to facilitate whenever there is a compliance audit. Now, what do we need to have in place as part of institutionalized structure to support it is that from the controller side, we would need to review all the key vendors or third parties who have access to personal data, either as part of a processing or as part of a transfer. Now, when we what it needs to be noted here is that processing involves any kind of an activity, right, including viewing at that point. So the controller will have to, as a first step, take a note and create like your inventory of third parties who have access to processing of personal data, and then do a review of the contracts that are existing to ensure that there is a mechanism in place, either as like regular SLAs that are reported, regular reports or audit reports that are shared, or a right to audit is being included within your contractual obligation, right? So that will be a responsibility from the controller side. From the processor side, you would need to ensure that regular audits are being are in place to ensure the how personal data is being processed, to make sure that you will be able to report to either the controller or to the authority via the controller about how the data is being processed. It may include allowing for regular or periodic audits by either a third party or by which would be a representative of the controller, or by the controller as professionals themselves. So the other responsibility from a processor is that the data is erased appropriately and a communication is made. So a documentation is also maintained that any data that is personal information is being erased or anonymized appropriately. Again, erased or anonymized based on the contractual requirements. So these would be like the compliance and the audit implications from a processor's perspective. Now, irrespective of whether you're a processor or a controller, one of the areas that you would have to have would again be like audit requirements. So these are some of the key areas that we would have to make in place. See, very first part, of course, is to evaluate what is the overall posture from a privacy perspective. Now, what feeds into the posture would be the data that is being processed. That would be very key, which of course leads to the type of data, the volume of data, the uses to which it is being put, and also the internal governance and the structure that you have, which will give you like an overall posture. Now, when I say internal governance, it means that are you transferring data outside of the Sri Lankan borders? Are you transferring data to a third party? Are you a controller or a processor, right? All of those needs to be taken in place, including the other parts, to give you what is your overall posture. Based on that, you need to ensure that the DPIAs are performed. So one of the acts from an audit perspective would be to ensure that the DPIAs are in place, they are documented, signed off and maintained as required, especially given the fact that there is a high penalty system, and the law mandates that one of the ways to demonstrate compliance is a DPIA, right? Whenever we are doing an audit planning calendar going forward, you'll have to ensure that privacy is accounted for. The key processes of business or systems, depending on how your regular audit calendar is structured, these are also taken in consideration into the audit planning calendar. We would have to, of course, based on the calendar, and then you'd have to evaluate the controls that support the privacy initiatives. Now, what are the key controls to be considered outside is, of course, things like the data encryption, right? It needs to make sure that key data, whether it is sensitive or whether it is special categories, need to be encrypted both at rest and in transit. There is access controls for databases. There is access controls for any direct data, access to data, be it structured or unstructured data, right? Especially when we talk about privacy, unstructured data plays a very, very key role. Unstructured data and data in hard copy or paper format. Now, there is privileged user management. One part of privileged user management, especially from an audit background, when we automatically think of admin rights, but here we would also need to think about from a business angle to say, does everybody need to be able to see, say, for example, be able to see data of multiple users? Do they need to see the complete data, or do they need to have a master view of it? So all of these need to be considered when you are looking at what is the role of the person and how the job function will impact the privileged user management. Training is a key, because a lot of your robustness of your privacy program is going to depend on the people and how you're going to manage the fact that people are aware of what is private data, what constitutes private data, and what are the responsibilities of each of the persons when they process it. So training becomes a very key aspect. Other areas of authentication of authorization, such as multi-factor, which we don't necessarily look into for us as part of our security. And of course, the privacy, overall privacy policies, those are also the controls that need to be considered. What are our audit implementation steps? Very first is know your data, right? And I think this is one part that all the other speakers have also spoken about, that you identify what is the data that needs to be done. The next step is to identify a relevant privacy framework. Now, as you identify the data, you will realize whether there is sectoral requirements, whether there are other country requirements that need to overlap, and then create a multiple framework that answers to multiple regulations. Specifically in the South Asia region, where we tend to work a lot with other countries, we do see that we have access to other countries' data. So there is a little bit of an overlap. We are in a very unique situation where we have to be aware of other countries' laws and regulations. So we need to make sure that those are also taken into consideration. And we are identifying whether we are controllers or processors, specifically when it comes to other geographies, and build a framework accordingly. So you need to have a framework which uses a common language between internal audit and key stakeholders. For example, when we talk about privileged access management, we understand that it needs to look into various roles and responsibilities, and not just from an admin perspective, right? So we link together all the regulatory requirements, having a privacy framework in place. Now we go to the next step, which is to have your first round of your risk assessment that is done. The offshoot of this would be able to help us identify and classify, what are your assets, what are your crown jewels, and whether you need to relook at how you have classified your systems and your processes, and also decide on your audit calendar and your offshoot to say how often you will be reviewing it, how often you will be looking into the DPIA requirements for this. So that is something that needs to come as an offshoot of your organization's privacy related risk review. Now, once the risk assessment results are there, we will be able to plan our audit plan, which will be able to give us a schedule of how often we will be reviewing, what exactly we will be reviewing as part of the audit. The fourth step, of course, is what we are all best at, right? Which would be execute the defined internal audit based on the exposure that we have, based on the type of controls that we want to focus on. So in conclusion, especially now that we have a new law, a law which has stiff penalties and something that we are not so far exposed to from a national level. We have three things. One is do not panic. You identify and empower the individuals, whether it is a DPO, whether it's a formal DPO, or like an entire team, whether it is part of, they can be part of any of these, like depending on your type of data that you use. It could be your HR, it could be your legal team, it could be your compliance team who's best suited to carry forward this process and gather the existing documentation, identify the data, right? Like that is our like golden rule over here, is to know your data, know which forms part of personal data and which does not. And you develop which will lead to like developing an inventory of the systems, the type of controls we want, what are the procedures we want, what is the type of governance and the structure and monitoring that we want to have in place. Make sure that we are looking at it from an extended enterprise perspective, which shows that we're looking at what are the requirements from the data that is coming in, which would may be our controllers or it may be our end data subjects, and also where the data is going to. So look at it at a holistic view. We would, and in addition, have a monitoring in place, have a communication in place, and have a very clear communication in place, which shows that any results of this audit or any recommendations that come from it is reported to senior management and communicate about the gravity and the risks that it poses to the organization. So these are at a high level what we would need to do to address the audit requirements. And that's about all that I wanted to cover today. So thanks a lot. Thank you for your time. I know that we did not have a forum where we could ask for questions, but if you do have any questions, please reach out to the ISACA members and then the team that has organized, and I'll be more than happy if they want to forward those questions to me. So in short, thank you all. Thank you for your patience, and I hope you have an equally fun rest of the day. Thanks, everyone.
Thank you, Madam. That's a very intriguing presentation. Next, we have Mr. Peter Lee, who will deep dive into the topic privacy in operational technology. Mr. Peter is a cyber risk leader in professional services business unit at Cyber ST Engineering InfoSecurity. He's also the director for academic outreach at ISACA Singapore chapter. He has over a decade of experience in the cybersecurity domain, and Mr. Lee holds a bachelor's degree in engineering specialized in information technology, a specialist diploma in IT security, and the certification CDPSC, C-RISC, CISM, CISA, JAC Critical Control Certification, JAC GSEC, and CISSP. So with that, Mr. Peter, over to you.
Pete, I think you are muted.
Yes, okay. So I was just hearing a bit of static, but I think I'm all right now. So that's the background. I'll talk about what we are going to cover today. So digital pathways in operational technology. So we need to start a foundation on digital trust in order that we can move on to incorporating OpsTech into privacy and the governance of the privacy concerns. Okay, so in this talk today, some key points. I'll talk about cyber risk. I'll talk about risk analysis. I'll talk about threat and attack models. Then next, essentials is to find a strategy in order that you have good governance and privacy objectives built in your approach. Okay, so that may include testing, validation, monitoring of risk, and then also training purple in the modern parlance, that the red teams and the blue teams actually support each other in making sure that you have a secure and safe and data protection for your system. Okay. So next, what are the OT pathways? So cyber risk is affected by digital disruption. So digital disruption, the new normal is having remote access and just one of the many cyber risks. Okay, so apps that you use to connect are not just from the corporate network or the offices and the data center. It's also coming in on the cloud and internet. So the apps will be everywhere. So what risks are there? There are risks that from any engineer who working from home, or it's a new normal. They've got apps everywhere, even in the mobile. They've got risk, cyber risk and cyber threats that are actually increasing, and it's non-stop. So it's going to expand, it's going to increase based on the risks that are out there. Okay, so users with remote access, there must be clear policies. So the approach in your privacy governance and the programs as suggested from our colleagues like Sumaya in Deloitte just earlier, and the way of managing cyber incidents, that's also laid down in your PDPA Act. Singapore has already crossed that journey for over 10 years, and it also had an update the past year in the cybersecurity regulation. So these really to make sure incidents are well managed and protections are taken from the lessons learned. So management tools and collaboration tools like our Office 365 that we're using now, it's very important that the security on the edge is looked at. So let's talk a bit about how to manage that risk, and we see that number one is to understand the multiple entry points. So the more we connect operational tech, OT, IoT, like building management systems, oil and gas systems, the more we connect them to IT systems, we need to understand the complexity and the effect that cyber risk will introduce. So these attacks will come from anywhere, okay? So let me point it out. So we've seen what Nalin earlier has pointed out on many of the increasing global cyber breaches. He's given an example of some of the airlines. Recently, in oil and gas, a Colonial Pipeline was affected. Even food processing plants like JBS and even critical infrastructure like water facilities in Florida were also affected by ransomware and anything that comes from the OT or IT supply chain. So anything that we direct access can be affected. In Singapore, we have already seen the evidence and the data on these increasing threats to personal data breaches. So the Singapore's National Digital Government Office has also received an increasing number of complaints that were directed at our privacy watchdog. This is equivalent to the Data Protection Authority in Sri Lanka. Okay, so our PDPC is a set of commissioners that receives these complaints, and a lot of them not just in the personal data but also healthcare data. I see like the Ministry of Health human immunovirus registry was hacked and the data was leaked out. Okay. Yeah, so that's a serious concern and ongoing. So what are the risks that we see has developed in recent years. So in a very long history of the data breach investigation report from Verizon, this key risk to crown jewels is whether it's OT, operational tech, or IT. We are always exposed to information disclosure, the theft of the data from the databases. Singapore, an attack on a bank from phishing. It's not the bank's infrastructure that was attacked. It was the telecom system where the SMSs were spoofed. Okay, and there's also tampering of systems in their application and the vulnerabilities they expose. Okay, and this is in OT. A lot of OT will take a long time to remediate because it's not a matter of days or weeks. It's a matter of months or years that an OT system would need to be fixed from its vulnerabilities. And also attacks from botnets by denial of service is still common. And other key threats, of course, in today's landscape, the insider is always the element where the attack can actually be modeled on. Human errors, ransomware attacks, and supply chain attacks are always increasing now. So major threats we've seen is that poor configuration. So cyber hygiene is where the concern really is. If anything is poorly configured, whether in the cloud, a container, or serverless machine, or APIs that are wrongly configured, these will expose any system to breach. Okay, and of course, let's look at training. Our concern here, maybe in ISACA, will focus on what training will properly ensure the organization takes care of its cloud services. And one of these threat models that we use, whether it's in OCS or in cloud, is from the MITRE ATT&CK. So MITRE ATT&CK has actually listed a lot of TTPs, the adversarial tactics and techniques. That's the ATT, and common knowledge. So this is a lot of things that we need to know. It's still a work in progress. It's been used for the last 7 years, and a lot of cyber professionals have made good use of this in their systems to manage the threats. Okay, the threats then we can get through maybe ISACA's methodology. We'll formulate risk scenarios, and then we can make the risk assessment more robust. Because why? With threat models that specify a specific cyber technique that's used by an adversary, the attacker can be actually defended against. So this thing actually helps the defender, the cyber defenders, stop attacks. Okay. Now let's touch a bit on other risks, the regulatory risks. In Singapore's PDPA that was mentioned earlier, and it's already 10 years old, there was an update a year back that actually modified the PDPA, the act itself, that now individual users are also liable for disclosure of stolen personal data, whether it's a reckless, unauthorized disclosure or intentional. This is subject to fine and jail terms. Okay, and of course, the increase in financial penalties is in terms of millions, not unlike what you have in Sri Lanka, millions of rupees. And also, the breach notification was the major change that means a baseline standard for any even small business in Singapore is up to 3 days. And if it's a long non-working weekend, there's really not enough time in a 72-hour breach notification to the authority. So locally, you have this law, and it rests on whether you have compliance, and a lot of financial penalties is geared to the non-compliance of the laws. So let's see how it rolls out over the next 2 to 3 years, and find out how it will be applied in your locality. Okay, and that's how you will actually adapt and change your risk assessments year on year. Okay, so let's talk about next in this next half of my talk here, essential to mastering this approach. Okay, what's the essentials? It's a strategic level of what you want to do. And for me, I come from the background of security testing and assessment. So testing is the main thing, validating the controls, and then continue monitoring and further training for the staff who manage data. So this is built up in a tower. You have your vendors or your internal staff properly trained to operate and to manage the systems. Like, for example, CISA to know how they're going to be audited for compliance, right? And then monitoring, security monitoring is your SOC, making sure you are looking at the correct risk. So the risk assessment should point to where you should be monitoring your systems for any possible breaches, like a CVE kind of attack on say Log4j, the Log4Shell attack, cyber attack, and that was actively attacking in the wild in a cause of data breach, just in a matter of days from its discovery. Okay. Then next, validating secure configuration to ensure that security is always applied continuously and the most secure configuration is pushed out for any production or live system. And then testing, of course, testing can be continuous. The next slides I'll show what it is to continuously test in the cloud. Okay, in the cloud, DevSecOps. Okay, in Azure there are a lot of facilities like way to test for vulnerabilities on the fly. So each day it goes by, there's a kind of a test done. Okay, what the data flows, what the violations, and what connected apps are in the system. Okay, and also the links to other system connected applications are all noted inside testing. Data management to make sure that there's a robustness in how the data and privacy management programs is rolled out in earlier program that's mentioned. I think Deepak mentioned on programs. So if you have the correct test for them, then you can actually flag out these policy violations. Okay. So testing is a multi-pronged process, and at every stage, from development to QA to the delivery of that release, can be actually monitored. And even an active application like using authentication and authorization, that is one way a supply chain was attacked. When the SolarWinds related hacking happened, the only way you could have tested for it is actually through what we have is the simulator. A simulator was available and made public just a year ago by Microsoft Azure. So this simulator in this hand-drawn process, right, describe how the authentication can be circumvented and how the certificates that manage the process and actually steal the secret keys for the Active Directory, that is the authentication mechanism in Azure, can be done. Okay, so it's called the Golden SAML token compromise, and that was simulated in order to study the SolarWinds hacking. Okay, yeah, likewise, it's not just Azure. Any cloud service, even AWS, has a whole gamut of over 40 different tools that you may need from your cloud service provider to actually use in order to protect and detect, respond, and recover from a cyber attack. Okay, so but however, there are simpler ways to manage this. In terms of like using a SOC, they will actually deploy the use of AWS's Guard Duty, this first app there, and then you'll use an inspector, you'll use a detective, okay, you'll use investigation when there's a detection of a possible attack. You make use of the CloudTrail, all the logs that's in your policy has been tasked to collect. Okay, that's part of data collection, right? And then the automation part, the CloudWatch, Lambda, and the manager in order to respond to any kind of hacking. Okay, so this is one way to build up and to understand how to defend from cyber attacks. Okay, next, training purple. What's that about? Because it's not just about attacking systems. The attacker must teach the defender. So that's why we call it purple. The blue team is supported by the red team. So the red team actually exposes what is the ransomware risk to your financial database. It exposes what's your hybrid risk to a finance database. You can even expose risk to crown jewels of your operational tech or inside your building, your OT systems. You want your elevators and all the controls inside a building system to actually not be compromised. Okay, so these kinds of systems are called attack surface simulation. There are also other names like breach and attack simulation. So these kind of systems continuously assess your cyber risk. They are monitoring it every day, 24/7. Okay, so these kind of systems are meant to monitor your risk day by day. Next, training purpose also includes inducting your IT staff, whether it's internal or vendor, to upskill from just the help desk knowledge. They got to identify what are the critical assets in security for your IT infrastructure, the architecture of it, and have built clear cybersecurity and privacy goals. Okay, and then they implement the controls properly from firewalls to routing and so on. Okay, and then they also respond and manage cyber incidents well. Okay, and beyond that, when I said earlier about red team and blue team, that's the cyber war exercise. So you build up playbooks and incident response plans. Make sure you practice, and do more practice. This will enhance your cyber maturity and your capability to protect your crown jewels, IT or OT. Okay. So finally, let's talk about monitoring. You know your enemy, and you know yourself, you will find that enemy. And that's why in terms of Microsoft security, they have the facility, and it's free for, I think, Microsoft infrastructure users to actually apply to study their own systems and to make sure they are defended properly and defended well. It all starts with risk analysis. If you know your own assets and you know how the enemy will attack your assets, I think you can defend it well. Okay. So this is the last slide. Can go back and recap. So I would actually like to share ideas with panel, but I don't have very much more to share this time. I can actually develop more in-depth things from questions. Okay, thank you. I hope that's enough to share with you.
Thank you, Mr. B. We would love to have you for another session as well. Maybe let's look, we'll speak to, we'll get Mr. Jonathan to reach out to you. Maybe we'll have another session on privacy, and we'll see as to how we can take this forward. Thank you once again. So next we have a session on the impact of privacy on security standards. This will be delivered by Mr. Abhishek Divakar. Mr. Divakar is a veteran information security professional with over a decade of experience in the cybersecurity domain. He is the founding partner of Ignatia Consultancy, the director certifications at the ISACA Bangalore chapter. Mr. Divakar holds a Master of Science in Cyber Law and Information Security. He is also a CISA credential holder, a CRISC, just to name a few. He is also a certified ISO 27000 lead auditor. Mr. Divakar, over to you.
So I think your mic is muted.
Sorry about that. So
Super, we can hear you now.
I hope I'm audible and my screen is visible. So yeah, let us start with see. So what is the impact of privacy on our security standards? So this is kind of seen as a problem generally, that like we have so many laws to kind of comply with. We get confused what like security is just another problem for our security professionals, privacy. So let's start. Something about me. I think enough introduction has been given, so I will just skip this slide. Okay. Uh, yeah, so let us start from the what are the types of privacy laws which we encounter in our life. So first one is definitely general privacy laws, which is like GDPR, our cyber laws of the country-wise cyber law, which does not go into any industry or kind of a specific reason. Like GDPR is applicable on Europe 27 countries only, but there is a clause, core clause 44, I think, yeah, which says that if you are using, if you are taking data of any European citizen outside of Europe, then also you have to comply. So it becomes like that, most of us, by nature of our business, of our companies, have to deal with somebody in US, Europe, or some other countries. You would have already seen what is the posture in New Zealand, right? So yeah, so like general privacy is like GDPR. Then there are some industry specific laws like HIPAA is there. Okay, then there are federal laws which are like applicable for whole of the US, and if you are doing business with US, then you have to comply with them. So this is like COPA, which is a child privacy protection law. Then there are state laws which are applicable in like specific regions, specific states. Like each of the 50 states of United States have their own breach law. That if there is a data breach, then what is the manner? Every state has a different law, where to report, how to report, in what is the timeline. And then there are several other notable laws, like you would have heard of CCPA, that California Consumer Privacy Act. Okay, that one is very famous these days actually. And then you have New York Department of Financial DFS, Department of Financial Services, I think. And you have Massachusetts have a different privacy law. And there are several laws, industry specific laws. You can see like there is a Driver Privacy Protection Act. So that is specifically for protection of like your driving license data. Okay. So yeah, just to give a view of like how many laws, this is not exhaustive list. This is just the major laws which we would have heard. Okay, you have LGPD from Brazil, CCPA, I've just mentioned DPPA, POPIA is just Brazil came up with some time back. Okay, PIPEDA, this is Canada one. HIPAA is that healthcare insurance. Okay, then state laws, DPA, that is UK one, and our India has come up with this PDPA. Sri Lanka also have almost the same name, and the laws also I've gone through. Not very different, but yeah, some significant differences are there. Then you have COPA, privacy acts have from different countries. Just to give you a view how many laws we have to comply with. So this becomes a problem. Like as an as a organization, any company do not trade in privacy generally. Company trade in goods and services, right? Privacy comes as a compliance, like we have to do if we have to be in business. Generally we do not jump into a business of privacy, but for us information security professionals, privacy becomes the business. So how do we keep privacy as like you can say least amount of intrusion in the business? So we have come up with many frameworks See, our focus is right now GDPR, which this is like across the world, most of the like worry is about GDPR, how to comply with GDPR. So for information security, we go for ISO 27001. For privacy, ISO has come up with another standard, or you can say extension to ISO 27001. This you can this is for the organizations which already have ISO 27001 or who are intending to implement ISO 27001. So if your organization is dealing in private personal information, then it's a good good thing. You can give a consideration to 27701 along with 27001. These two kind of will be good enough, and it's not 100% compliant. Like if you implement 27701, you cannot say that you are 100% compliant with GDPR. There will be some delta always, and that goes for most of the laws. But if you comply with this, then the delta will be very little from whatever laws you are intending to comply with, whatever your law is applicable, or your industry, your region, your country. So this is a kind of good base point to start with. So what is ISO 27701? This introduce a like PIMS, Privacy Information Management System. So you would have gone through ISO 27001, that is ISMS, Information Security Management System. PIMS is just a, you can say, rider on top of ISMS. So this standard talks mostly about how can you design a PIMS on top of your ISMS, how it will interact with your ISMS, how will it will integrate with your ISMS, so that you can make security as a regular business as usual activity, which we have accomplished through ISMS. How can we do that for the privacy also? So we have to make see some considerations whenever we are collecting any data from any customers or any users. Then we have to make consideration what data we are collecting, what purpose it is for, what use we can put that data to. Can we process it for this purpose? Can we process it for that purpose? So these many things is not directly mentioned in ISO 27001, not in detail, but they have mentioned that privacy requirements must be considered. So that's how PIMS comes into picture. Okay. So let me just give you some points about 27001. It's an extension to ISO 27001, means you cannot directly go for 27701. You have to have a 27001 certification in place. If you don't have, you can go for both together, but you cannot have 27701 alone. And see, like it is said, privacy cannot be implemented without security. So security have to be there. So security you can get by ISO 27001, and then 27701 gives you assurance about the privacy also. And it kind of makes a robust model in your organization, so that suppose you start doing business in a new geography tomorrow, where there is a new privacy law or some new for you, for instance, that you have to comply with this law also. Now you don't have to go back and kind of shuffle your whole information security management system and kind of try to comply with this privacy new privacy law, because this PIMS is made for kind of generic, kind of agnostic of any laws, but it covers most of the things which any law asks for. Okay, so yeah, and feel free to ask any questions if you have any questions. I will welcome any questions. Okay, so why it was developed? It was developed to provide a standard for privacy controls. There were several standards for information security control, but not that much emphasis was given on data privacy control in any of them, or most of them, you can say. Okay, so that there was the need, like when in 2018, when GDPR came out, a lot of people were worried how will we comply? Because GDPR is like GDPR is a regulation. It's like nobody will certify you, but if something happens, and then you will get audited, and then you will get penalties, and penalties are very high, that you would have seen in some previous presentations also. Okay, so how can you kind of be comfortable that your organization is not getting not at the risk of a data privacy breach, or tomorrow if a breach happens, the regulator will not come to your organization and kind of put on a hefty penalty on you because you did not do enough for your data privacy. So this 27,701, this is PIMS, which is it's a good way of demonstrating to customers and regulators and your stakeholders, etc., that you have made effort to like comply with GDPR and privacy laws, and their information is safe with you. So you will have like ISO 27001 also. One purpose of that was to give customers and vendors like your partners some assurance. This also goes on top of that, that you maintain privacy as well. Okay, and it directly maps with GDPR. So GDPR requirements, if you see, it has given in one of the annexures also of this legislation. Sorry, this standard that yeah, so it maps directly with GDPR. Okay, let's these are the benefits of PIMS. So first and foremost, what the reason this regulation was created, it support compliance with GDPR and other data protection laws, yes, but GDPR is the focus around which this was built. Okay, there is no official statement till now that GDPR is accepting PIMS as like so proof of compliance. They will still independently audit and ensure that, but still for your preparation purpose and for kind of moving around in the private sector, this PIMS is good enough actually for GDPR compliance. Okay, and it improves the structure and focus of data privacy management, because earlier whatever information security systems we had in place, they treat generally like data in this way, like confidential, most confidential, restricted, or public information. Okay, but this adds a new section of private information, sensitive personal information. Okay, and how do you like how do that data moves across in your organization? Okay, next is this yeah, this is a, and this takes a risk-based approach, same like ISO 27001, but for privacy management. Okay, and this also includes a continual improvement plan for your privacy management program. Okay, it integrates with the other standards also, 27001 and some others. Okay, now what is this standard? Like, how does this standard is framed? Okay, so it's like when you look through the standards, so clause 1, 2, 3, and 4 are like a standard ISO clause which you will find in all the standards. So let's after skipping that, actually standard starts from clause 5. So clause 5 describes what is privacy information management system. Okay, how it is linked to ISO 27001. Okay, and it goes through, like it takes you through each clause of ISO 27001 and adds what you have to do for privacy. What are the requirements? So like you would have seen ISO 27001 and ISO 27002 are like 27001 is the regulation and 27002 is more like guidance. You can follow 27002, it's a good practice, but if you don't do whatever it is written in 27002, you can still be compliant if you can do something differently or do something better. Or if it meets the requirement of 27001, then you will be certified. So same way, clause 5 specifies requirements which are mandatory, you can say. Okay, and clause 6 links back to 27,002. So mostly like guidance, all 14 categories, 35 control objectives, 114 controls, which are mentioned in 27,002. It goes for with each of these controls and gives the privacy consideration. So how like you can get certified? See, there are two ways of getting certified for this. Either you can depending on your budget and your like how much manpower you have you to spare for this, either you want to do this first, and there might be client requirements also. So you can either go for like 27,001 first, then wait for like some time for it to get matured for a year or something. Then after that you can go for 27,701 for PIMS. Other thing what you can do is you can go for them together also. That is also it's a bit more you can say time consuming, but overall it will be beneficial because you get the full framework in one go. Okay, and how this clause 6 goes is clause 6 also takes you for each of the controls which are mentioned in ISO 27001 2. Okay, and adds, like for instance, you take an example of access management. Okay, so user access management, there should be review, there should be access only should be given by after approval, the segregation of duty should be considered. So you add one more thing, that privacy also should be considered. Whatever data is being given access to, is that private information? If it is private information, can this person access it? So this consideration you have to add in access management. Not a lot of change, but yes, some changes from then your ISMS plus PIMS becomes like that. Your organization slowly starts thinking like that. So every time you start, let's say, new access request come, you at least think about it. That should I give access? Is this private information? And slowly it develops a culture in your organization also that you can say centers around privacy. Like all of your employees will start considering ISO 20 this privacy as a important kind of factor, and awareness and all everything is added to the this framework. Then we can see for clause 7. Then see, initially you have to decide. All the organizations, mostly whichever we have, they are generally controller, data controller or data processor, and most of the organizations are both. You might not need a certification for data controller. You might only be data processor. For instance, if you are processing data you have taken from client, okay, client is collecting the data, and client is, or you are collecting the data on behalf of client, that is also fine. Okay, and but difference between data controller and data processor is who decides what happens with the data. Okay, processors only are authorized to process the data in a way which has been authorized by controllers and is legal. And controllers are the one who are who get benefited from this data. Okay, so initially in clause 4 itself, you have to kind of decide what you are. You are a controller, or you are a processor, or you are both. Okay, so see, you don't have to be certified for both. Then if a large company, they have to be generally go for both, like controller and processor. But the smaller organizations like us, like we can definitely go for just processors. Most of us do processing jobs, data processing. Okay, so let's say client have collected the data and given it to us for processing, and at the same time how we are also controller, we are also taking data from our employees. Okay, some of maybe our let's take Sri Lankan's context only. So let's say from Europe data is coming for European clients and European users. Okay, for that you need to be comply with GDPR. For that this will help. But you are also collecting data of your employees who are there in Sri Lanka, and their information will be with you. So that data also you would like to protect, but you don't want to go the kind of distance for like equal distance for both. So generally what I have seen is people go for processors, the certification only. So clause 7 outlines the requirements and control objectives for controllers. Clause 8 is applicable for processors. Same goes for Annex A and Annex B are mandatory part of this. So there are two parts of this. You can say mandatory part like ISO 27001 only, mandatory part, and then informational or non-mandatory part. So this page you can see this is mandatory part. Annex A and Annex B. Annex A is mandatory for controllers. Annex B is mandatory for processors. Same goes for clause 7. It's mandatory for controllers, and 8 is kind of mandatory for processors. Okay, then there is some more information given in the standard itself. So and then Annex C is mapping from 29,100, which is original privacy, you can say, standard released by ISO. Like what is the need for privacy, not how, but what is exactly is needed to be done for privacy. Okay, and like I said, Annex T provides a mapping, direct one-to-one mapping to GDPR, how you can comply with ISO 27001 and show compliance with GDPR. So like for each GDPR requirements, how can you like how if you get a query from data protection authority. Okay, how are you complying with this, or have you implemented GDPR? Then you can show, yes, these are GDPR controls, and against that we have implemented these controls, and that mapping we can directly get from here because you have implemented 27701. It will be very easy to do. Then Annex D gives you a mapping to ISO 27018. 18 is just PII in public cloud. So whenever you are using PII and moving it around in the public cloud, or you are storing it in public cloud, there are some other consideration. So 27001 has taken care of it. It is already there. But 27018 also you can just have a look why we do it and like how it should be done. It is there. And then Annex F is mostly about how do you implement ISO 27701 on top of your 27001 and 27002. Where do they link? How do they integrate? Okay. Yeah, and yeah, I would definitely want you guys to ask any questions if you have any, because this is my last slide. After this, just why we do privacy. We are protecting data for individuals. And like Rihanna said, sometimes you just need your privacy. Yeah, so that's all from my side. Any questions, please?
I'll talk to you. If there are no questions, I guess we can possibly reach out to you via email. So if you all do have any questions, do let us know. Thank you, Abhishek. Thank you for that very insightful presentation. The last individual session for the day. I can see smiles on people's faces. So it would be about technical security in establishing privacy. And this will be covered by Mr. Mohan Chaturanga. Mr. Mohan is a veteran in the domain of IT governance and data protection and information risk management. He's currently the head of data protection and IT governance for MAS and membership director for ISACA Sri Lanka chapter, and is also the co-chair of the Cyber Security Center of Excellence for SLASCOM. He holds a bachelor's in computer systems and networks, a master's in business administration, CISM, CISA, CDPSE, ITIL, AWS, just to name a few. think you all are in good hands. I'll hand over the session to Mohan. There'll also be a panel discussion that will be happening after his session, and Mohan will be moderating. So with that, I'll hand over the controls to Mohan.
Hi everyone. Thanks for coming in, and thanks for that introduction, Nelushi, and thanks Isaka for having me. And I know that I'm standing between you and your lunch. Sorry for that. I think it has been very informative sessions from the morning, and I think a lot of people have been speaking about what to do, how you interpret the Data Protection Act, how you interpret multiple regions data protection acts, and what you need to implement and how are you going to implement that. So I'm that, I would say lucky or unlucky, that guy who is actually implementing at this point of time. And so just to give, before we start, just to give a quick background. So from 2019 towards 2020, I've been doing the work for DPO for MAS, for the group of companies, and acting as a data protection officer. So I'm kind of implementing GDPR and in some of the other regions where we operate into some of the other acts and compliance requirements as well. So I'll try to relate to as many places as possible where some of the things that we discussed from what Soumya was explaining, Deepak, and what Peter was explaining related to some of the security controls. And what does it look like in the actual implementation? What does it look like when you really do it? And what are the challenges that you're going to see? And from my experience of implementing that, so when I initially started this journey in 2018, yeah, I worked in consulting capacities with some of the leisure sector clients in Sri Lanka, and then implementing that at MAS. So what I want to really understand at the very beginning is where this cross-section happens at privacy and security. Because when you operationalize whatever that we have been discussing from the morning, we want to have a clear demarcation of what are the privacy principles that we are going to implement and what are the security principles that we are going to implement. So, because in the actual implementation, it's not you're not going to reinvent the wheel. So if you're a bank or if you're a telco, so you have already done some certain security practices already, right? So it's not that you're going to start from scratch. So you will have certain security practices, you will have certain risk management practices that is already been established. Now we are going to connect all these here, right? So that is how you primarily go towards a journey for privacy. So when you look at it like that, so security is a measurement of certain level of controls technically that we have implemented. I think Peter touched base on some of those controls, how we implement them. And in the areas that where most of the speakers been speaking on, there are privacy controls which are there. So the ideal concepts that we want to have in our mind is that in security, we look at confidentiality, integrity, availability, from an access control point of view, border security, layer defenses. We go into those concepts and we build them into the organization. So now you go take a step back and think of all those from a consumer's point of view and try to understand how all that is going to affect you as a person. So the best way to think is, so if you're in the cyber security or information security domain, implementing all these controls in your organization, now step back and think, as a consumer, is this helping me for protecting my information? And is this experience good enough for me to protect my data? So that's a very easier way of starting your changing your point of view towards privacy, right? So as a natural person, is this helping you? Is this security implementation helping you? Then you try to implement or work towards those privacy concepts that we are working on. So for an example, data collection and data minimization, the principles that I won't go into there because we have been speaking about them in the morning. And how we manage this scenario is around certain security concepts. right? So privacy by design, incident response, data handling, third-party risk management. So I will touch base only on these areas. Maybe in on a different session we will touch on in detail about some of the technical implementations as well. So I will try to relate to these concepts as practically as possible and try to give you an overview what it does look like in the implementation. So some of the challenges we faced early on is so we being in the apparel manufacturing, primarily the bulk apparel manufacturing, but now we are moving into knowing our customers. So previously we did manufacture and send it out to customer. We didn't know who Miss Jones was, right? So Miss Jones was a customer of our customer, right? So we didn't know, but when we started co-creating and getting up in the value chain and delivering directly to the consumer, where the consumer orders it online and it's going to be delivered with MAS. So then we get to know who our end customer is, right? So then we get to know where she lives, we get to know what she wears, we get to know what she prefers. So that is personal data, right? So when we start working with customers in co-creation space, so that is how B2C, when we work, privacy regulations get applied to us. Then in the larger domains where the new fabric comes in, new technologies, integrated fabric technologies, that means for an example, thermal recognitions and smart wearing. So some of them might be surprising for you because data transfer through fabric is some of the areas that you look into. So basically you wear something and it has data transfer mechanism. The VR that you're going to wear in years to come will not have any data links attached to it. It is basically connected to your fabric, whatever that you're wearing. So it will have data transfer mechanisms in your fabric. So thermal recognition technologies that we work with, some of them would have the doctor remotely would know their patient's body heat, right? So what they're feeling like now, what they feel. So these are what we call as SPI, special category of personal information that's going to be stored in these integrations. So these are some of the spaces that we work with, and how we put them into solutions in privacy by design is something that we have all of us were wondering, because any enterprise or any organization would start at a point. You can't go back and redesign your solutions. They are already designed, the architecture is already done. So we want to start from a point, how can we enhance this? So privacy by design primarily talks about the cultural shapes, process improvement, technology enhancements. In privacy by design, what you mean is that, I'll go to some examples, but the point here is that any solution that's been designed and the customer, what customer is experiencing, in the design of the solution, you have certain privacy elements done correct. So when you log on to a solution or a system, the consent is taken at the very beginning and it's very clear and concise, right, at very beginning. And then when users are going through how you collect for new services, so if I'm using the banking app, right, maybe right now I only have personal loan facility. I want to move into credit card. What more information are you going to take? Or have you already taken every information that you know at that moment from a KYC at the very beginning? But then the problem is going to arise, was that necessary? Because I was only applying for a loan or I was only applying for a credit card, right? Do you need all the information that you need? So these are the design consideration in an app that you need to understand at the very beginning in terms of data collection, which was just one element that we discussed. And then if you move into things like data minimization, encryption, so that's a technology that you need to embed into the architecture at the very beginning. So people who work in the technical domains would understand you can't have an encryption once you have done the costing and wrote an RFP solution. You are not going to go back and do encryption on the database because that has the dependencies on systems. So that's why you need to understand that at the very beginning, privacy design need to come into play. And those are the technology enhancements. And the privacy governance. So for an organization, if customer is onboarding, you need to understand there's a governance structure there. So for us, we started with the DPO, established a privacy team, specialists are there, incident respondents are coming in, working with partner ecosystems, and what's that governance look like? And that DPO is going to go for a CEO or reporting line, how are you going to establish that whole governance space? And the cultural shift is mighty, right? So we are on the same side. I think Soumya was congratulating us for taking a leap of faith towards Data Protection Act very early in the region. But at the same time, we need to keep in mind that privacy is not a concept that the consumers in the country is very well aware of, right? So we are not aware of it. So privacy, if you take data privacy, one other area is territorial privacy or things like that, right? So we are a generation, we sit very close to each other, right? If you are in a queue, you feel people coming very close to you. So that is my territorial privacy, right? But we are not savvy to it, right? So you would see other countries who are savvy to it. So privacy is a new concept for us. So things like that. So cultural shifts in terms of data privacy is also there. Certain process improvements. How is your customer care center is going to respond to your clients going forward? So you're going to call and ask. I get all the time calls from banks, and the first thing that they're going to ask me is, can you tell me your birthday and can you tell me your NIC? Like, goodbye. Right? So that is privacy by design. So if you're designing call center services as a process, that is not the first question you're going to ask. So that process needs to change, right? So these are the improvements and changes that will happen when you implement them practically. I won't go into detail, but I will pick on few areas. Proactive, preventive, and not remedial. I think Soumya was explaining about the audit framework, right? So there to understand how you reactively or rather corrective controls are there. But the thing is, if audit comes back to you and say you need to have synonymization because you have health data in your system, hardly you are going to go back and change a $20 million system in a year, right? So you can't close that gap within a year. So it is very important in privacy technologies, and when you work with it, you have to be proactive. So the thing is, if you have a 36-month gap to implement or comply to the Data Protection Act, IT projects which are kicking on right now need to consider the privacy concerns. You are not going to come back and change the application architecture. So if you're looking at a maybe cloud, if you are a bit of an open architecture, might have a chance to say take certain technologies. But these are more centric design, data center design systems, you will have a tough time doing that. And privacy as default is that these are not selections that we want to have, right? It's not that someone is going to call center example, the call center person will call and ask, shall I ask you the phone number and then I see, or shall I take another one? No. It's by default, it should not ask that question. So that is what practically it looks like. So if you look at full functions, so positive sum and not zero. So here is a conversation which I go through every day with our design teams and our development teams, that it's not a sum zero exercise. It's not whether, right, okay, now the design is going to suffer because we want to embed privacy. So it's not. I'll tell you certain examples of it. I just have a practical example for it as well. I'll come to that before. So design is a win-win, right? You can't say, after all the development and the go live and you go to the business and say, this was looking good until it came to the DPO, now it doesn't look good. Because we embedded privacy to it and the solution is not user-friendly. That's not an answer. So that's why I think I saw it in Deepak's presentation where organization areas like operation, legal, and technical, all those areas. That's why a DPO or a privacy office need to work with all the teams to make sure that the solution is also designed and delivered in the right manner, with the right functionality, but having privacy controls. So that is an important piece practically that you will face in implementing this. And end-to-end security, the full life cycle protection, I'll touch base a bit on that in the incident response, but that was the areas that Peter was speaking about. I won't go into detail. The technical security, what you currently have as organization, security, cyber security, those would come into play. And visibility and transparency, I think we've spoken about that. Respect for user privacy. So ensure there are multiple touch points around your system and how you implement them, have areas to work on this. So maybe I'll keep on it for the time being. Just want to take a quick example for you what privacy by design looks like. Maybe you can take out your phone, just have a quick check. It'll take 30 seconds to do this. If you just take your phone, right? So you go to Facebook. People who are not in Facebook, I'm sorry for you. So you just switch to Facebook. You just go there and just scroll it down till you see your first ad. If you just say sponsored, right? To just say sponsored. You know what ads are in Facebook, right? So even in Instagram, you can try this. So you just scroll and go to the first ad that you see, right? Now go to the 3 dots that you see there. The 3 dots on the right-hand upper corner. If it's an iPhone, 3 dots, but in an iOS, it should be 3 dots. So now you see, you go to why am I seeing this ad? You go to why am I seeing this ad? You get to know why you are seeing this ad. So it was, how many clicks did you spend on knowing that? 2, right? So, and was it difficult for you? Was that inconvenient in the functionality of it? No. Was that a distraction of the actual functionality which was to push the ad in the first place by Facebook? No, because it's just 3 dots. So the ad was effective, so ad was working. So this is what privacy by design looks like in practice, right? So the solution is also effective, but at the same time, user will also get to know why they're seeing this ad. Probably might be seeing a lot of embarrassing reasons why you are seeing this ad as well right now. But apart from that, why are you seeing this ad, right? So this is what privacy by design in practice looks like. So I just wanted to give you that example. And so I have subscription on McKinsey, so I'm seeing ads then in Facebook. I've been looking for a land. I'm seeing these lands coming up. So you get to know why you do this. So I hope you understand what this means, privacy by design in actual implementation. So now maybe if you look at certain local implementations, you know how it looks like. So these are the areas that we want to improve on. We'll be able to play this for you. Yes. So this is the example I want to pick you up on how you can educate user, the whole piece that you have on consent, how the work works on your policies, privacy policies and everything. How does that whole piece works out? And this is one of the largest PII processors in the world and how they have created and put them. All right, maybe in the interest of time, we'll skip that. Can we have the slide now? So I'll send that across to you in a link. And the few last pieces that we want to look at is the incident response. So incident response is the piece where we connect back with the concept of the breach notifications, right? So where the breach happens, how the breach notifications work. How quickly are we going to know about a breach? So here the thing is, whether it's a data breach or an incident, usually any organization, any corporate will have something called incident response plans. So in incident response plans, what you're going to see is a way of responding. Right now, security teams, IT teams are responding to these events, right? So when they're responding to these events, it's extremely unlikely, unless you define that very correctly, that they are going to identify the difference between a PII breach and an actual security event, right? So most security events are different in nature, disruption to IT services, but how are we going to demarcate between the PII related data breaches and kind of incidents is something that that is something that you need to be mindful when you're establishing these posts. So here unlawful, so if you look at PII, the Data Protection Act, what you're going to see is unlawful processing, attempt to gain access, lot of personal data, lack of access, distraction, damage or alteration. What you're actually going to see is an EDR response, which will have a lateral movement, risky access logins in an email, right? So, or rather destruction, or maybe that means a backup being getting deleted before a ransomware being executed. So the actual events differ from what we have been interpreting, right? So Privacy Act will tell you certain events or incidents that you need to have response for, but you need to make an interpretation to the IT team saying, guys, in operation, what does this mean, right? So one of these things could lead to a privacy incident. So that is why in your IRT, now we are evolving to incident response plan or playbooks. So when you evolve like this, in this practice, somewhere you need to define where in your IRT that PII related incidents are coming up, right? So this is where the privacy office or the data protection office need to get involved and work with the response teams, IRT teams or security partners to understand probably which phase. So when you're doing the triage, that there would be an impact for data is going to be identified, and actually your privacy team need to get involved. Otherwise, you are not going to know that there's a breach which has happened. Now here the interesting part is, I think even during the drafting days of DPA, we have been providing feedback to this as well. 72 hours to respond. So usually, I think people who are here in cybersecurity would know that the data being exfiltrated and put into public, and you will get to know most probably after 6 months, right, or 3 months, right? Unless you have a robust detection mechanism of data being leaked, that means technologies like DLP, you'll likely get to know about that dump months later, right? Even the incidents that you have within the organization can't be noted to that. So these are some of the practical challenges that you might need to work towards. And the data handling piece, I won't go into detail, but one thing I want to understand is DLP solutions are there. So these solutions will let you know that data is being leaked at certain egress points. What we mean by egress points is any organization will have SharePoint or whatever cloud platforms to share data, email, some have USB as well. So this every point you need to monitor. So for an example, we monitor thousands of endpoints around the world for events like this, and practically for our numbers, we have about 1 million emails going out a day, per day. So monitoring 1 million emails, which one is getting leaked, is a massive exercise. Unless you have a lot of tooling options invested in, it's extremely difficult to handle. So these technologies will organization need to prepare themselves for at least 1 year, 24 months to come to a maturity where you can actually invest on that tool and get the benefit out of it, right? So these egress points you will need to monitor in order for you to know that there is a data leakage, right? Otherwise, it's just million of files going here and there, you would not know many things. And in data retention, I think in this space, you need to have a larger spectrum of a different topic like data governance, how you want to establish. But if you just look at retention piece, so you might need to understand how long do you want to keep your data. If you look at right now, majority research-based, 40% of the data that you have in your organization, you don't need it. You don't need it for any purpose at all. It's common for everyone, the data that you hold, you don't do anything with it. So how do you want to get rid of that data in the first place? Is a real thing that you need to do, because if there's 10 million penalty to it, if you have 40% of your data which you are not using, someone coming in and taking that particular set of data is a disaster for you. You are paying a penalty for something that you own which you don't use, right? So things like that. So minimizing that space is something that you need to work out, where data protection office need to come in and figure that out. Last piece I want to touch base was around third-party risk management. You work with a lot of partners. I think your development is outsourced. The work that you do is outsourced. A lot of partners involved. In IT, if you look at ODM is very limited, and you will have a lot of partners. How are you going to manage them? Because the data processor piece is going to be very large than the actual control piece. So that is where, so we work with our legal team very closely to understand our contractual obligations. What are we going to do? How are we going to tackle this? How are we going to understand the supply chain security? So that is why all these teams need to get together. IT, legal, risk, DPOs need to get together and understand your processes. Their contractual obligations, how are they processing? So processes are larger than the controller space that you have in your most of your organizations in enterprise scale, right? A lot of your data is with your processors. So basically, what are the risks that you have? So basically do an assessment around that and have due diligence whenever a vendor is onboarding. That is a real key piece, right? We have vendors onboarding, it's just the face of the organization that we are seeing in Singapore somewhere, but they're actually operating from India or a different region. So get to know them. Do the risk assessments, understand which layer each and every organization is at. And we are working with like that, we're building programs to mature our partners as well. So we tell them, hey guys, take 1 year, 2 years and come to this level. We require that in our roadmap. So those are the conversations that we're going to have. So these are some of the areas that I want to put you up. I'm trying my level best to give you the best slot for the lunch. So I'll be here around. So you can catch up with me. I'd like to share any information that you'd like to have. Thank you very much.
So the last session for the day would be the panel discussion. We have Mohan Chaturanga, who will be moderating the session. And for the panel, we have Mr. Rudhika Dialis, Managing Director and Co-founder of Trust Board, Ms. Tanushri Sanaka, Manager Legal ICTA, and Ms. Ashwini Nadesan, who will be joining us virtually. She's the for a company in India, and she's a research fellow and a renowned lecturer.
Thanks, Tanushri. Right, so in the interest of time, I think thanks, Buddhika. I think you would have a lot of things to share with us today. And I think we have been going through Tanushri's presentation. And thank you very much. And there have been a lot of thoughts around, and thank you for that introduction to that as well. So I'd like to actually start some of the questions around the piece from about cybersecurity, and I think Buddhika is coming from the background of consulting, working with most of the enterprises in the country. So just want to understand what is the readiness and where are we? What do you think will be the biggest challenge in complying and working towards these kind of regulations for Sri Lankan enterprise? What do you think?
As a consultant, I got engaged sometime back when it comes to privacy with the industries that we are working with, particularly software development companies and all that. And I think in Sri Lanka, the move with the Data Protection Act that came very recently, now the organization is talking about this and how we are going to implement the act, and the requirements coming in the act is being discussed now. So the when I talk about these aspects now, software development companies, they are servicing privacy acts are very aggressive, and they are very, even the customers that they are providing services to, they are looking at compliance very, I would say, religiously. So for software development companies, we actually, like you said, it's an extension of security. Security is the bigger arm, right? And the governance practices and all those things needs to be extended to privacy. If we have done information security policies, we have to extend that to the privacy side. So privacy talks about how we manage the personal information, and the security talks about how we protect it. Now the challenges, that's the very interesting part, particularly the organizations that we have right now in Sri Lanka, and organizations who servicing outside. Challenges, when it comes to challenges, the key one would be most of these organizations are using cloud technologies heavily, right? And certain aspects of the privacy laws, privacy requirements that we have now, for example, the right to forget, right? Now, the challenge is that how you are going to delete a particular piece of information with a click of a button if you are in cloud. Because we also don't know where exactly our data is stored, right? So these kind of challenges came in, and major cloud service providers like Microsoft, AWS started mentioning where the data is going to get stored, and giving the option even to the customers to select where the data can be stored, even in what jurisdictions and all that. Saying so, still certain customers have this doubt how they are going. I have to be, if I'm going to put my data into the cloud, I have to be assured that my data will not go into another customer's database, right? Or it will not get breached. And how these cloud service providers will implement their security aspects. So these kind of challenges are there. Governance aspect is one, the technology aspect is one, right? In the governance aspect, yes, there are certain organizations, even in Sri Lanka, they still don't know the purpose of collecting that information, right? Now, for example, if you go to a pizza place, right, they'll ask you a birthday. Have any one of us asked why you need my birthday? I want to get the food, right? Why you need? Right? That's where we need to have our thought process, and even the organization should come in and say that, okay, let's minimize the data we collect. The minimization is the first approach that we need to target. Okay, the more data you collect in, the more data footprint will be available in your organization, where it will be very hard to control these areas. It can be electronically, it can be physically even, right? So that is slowly coming in. This is what I see wherever the places I have gone into. In a organizations, BPOs have adopted a lot of privacy practices already. Which comes to our local organizations who's providing services to us, because obviously they have to be compliant with the Data Protection Act anytime sooner or later, right? To how they are going to implement, because most of the technologies are legacy, right? They have a lot of loose ends when it comes to technology. They don't have control over the data, right? And on a governance aspect, they servicing. So that's the challenge that is coming in. If you ask me how the readiness on the local organization, still primitive, still they are taking the footsteps, but the international organizations, they are multinationals, the organizations that particularly even MAS, any organization who's working with foreign customer base, they have started this. They have reached a particular maturity even, but local companies, it's a challenge.
Thanks, Pradeep. I think I quite agree with that as well. I think that's a good perspective. We have a long way to go. So I think all of us would understand that, and luckily, Data Protection Act has given a long way to go as well. And there's a grace period that we can work with. So Tanush, actually, I wanted to understand from you. So you were talking about how the legislation was formed, what's the background to it, what's the logic for it, and all that. So when all this is, end of the day, is a consumer protection mechanism or consumer right rather, right? So when consumers are not aware of it, even though the act is there, it may be prone that organization might not necessarily be compliant, because even they were not compliant, people would not know. So what would be the mechanism, the approach, the things that would happen going forward that the consumers will be more aware about their rights, what this means, and what is the data protection means? How are we going to aware them more going forward? And in Sri Lanka, what are the programs? What do you think is the right way to do this?
Thank you for the question. Actually, we have always talked about it from the company's aspects and how the knowledge can be transferred, how there can be awareness programs and so on. But of course, when it comes to the customer, it is really important that the customers and the consumers are aware of their rights, as we rightly mentioned. But most of the time what happens is that even though the customer or the consumer is not aware of the rights, it doesn't make the right or the obligation of the company any less important. Because even now, even if you take any other legal provision in the company, most of the citizens of the country are not aware of what we are entitled to. And which is also the reason I don't want to be so political in a platform like this, but I think most of the time why we are in this situation is also because we are not aware of our rights properly. And that is affecting every single one of us at this point, and we are all going through something really severe and a crisis situation. So it is important for every citizen to know what we can do and what we are entitled to, and the knowledge that the knowledge of it, the knowledge of the law that you get is something that is readily available online. Because there are organizations like the International Association of Privacy Professionals, and they issue certifications on, like there's a qualification called CIPP, that is Certification of Information Privacy Professional, and then there's a certification for Information Privacy Manager. So there are certain professional qualifications that the corporate entities can carry out, and also it is really what is more important to know that whether the consumer is aware of the right or not, the company needs to be responsible enough to carry out their duty as a responsible corporate citizen. And just because the consumer may not be aware of it doesn't dilute our responsibility any less. And the way that we can make the consumer aware is by carrying out the awareness program like you do with any of the products that you come across. So many organizations, they do awareness for the customers on their products that are available. So likewise, the best way to approach this, I think, if the organizations are taking it into their hands to educate the customers, the best way to approach this would be to ensure the customers that they are doing it that the organization is doing it for their own good, for the consumers, and without exactly going on the legal basis of it. And this will actually give you more, it will make the company more responsible, and it will bring a good name for the company and the organization, because then the consumers will have the understanding that the organization is going a step forward and taking care of our details and our rights more than even before we knew that we were entitled for it. So it is the responsibility of the organization. It is the responsibility of the up and coming the Data Protection Authority eventually to make sure that the awareness reaches the citizens of the country. And of course, as implementation agencies, ICTA in platforms like this, we have a responsibility to take that message forward. And that is, I think, how the citizen education needs to be carried out.
Sure. Thanks. Thanks, Narushi. I think that's an insightful answer for all of us because it doesn't make it any less severe when the consumer doesn't know that it is not. So as an organization, we do hold a lot of responsibility in making sure that we comply. I think I've got one question for Ashwini. I don't know, Ashwini, where you are seeing us from? Are you seeing us from the front?
Am I audible? Am I audible?
Yes, you are audible.
Right, thanks.
Hope Ashwini can hear me. I just want to ask Ashwini from you, or primarily, I think at the very best outset, one of the organizations who work with is, I think, Europe Chamber of Commerce was also they are initially drafting this act as well. So when we comply with legislations like this with the larger part of the world, what do you think for sectors like IT, BPM sectors, people who are exporting from here, being a country where the data is being protective and thought ourselves as the destination where the data is safe? What would be our advantages? What is the background to it? How good would that be?
Thank you. Right, you are asking whether being compliant with or having a data protection legislation would further opportunities in sectors such as maybe business process outsource or trading or IT. Is that right? Okay, thanks. Thank you for that important question. And I must say that my work is essentially in Sri Lanka, and it's unfortunate that currently I'm not in the country to be a part of the panel. So apologies for joining virtually, but thank you for inviting me. To answer your question, I must say that if we start with the GDPR, which is now being widely discussed, even in today's panel discussions, it's been repeatedly mentioned by a panelist from earlier in the day. But not just GDPR, in 2020, there was a decision called the Schrems II, as we now know it. Post Schrems II, there is a requirement for any entities in the EU, that is where essentially the GDPR applies, whenever they are sharing data of data subjects in the EU with any other country, they need to make sure that the data protection, maybe procedures, legislation, and practices in those countries are compliant, or they would pass what you call as a data impact assessment. They would need to do a data impact assessment before transferring such data. And as has already been mentioned, Sri Lanka will essentially be a data importer where data is being sent here because there may be organizations which are processing data belonging to those in the EU. And we have also advised many entities where they wanted to transfer data to Sri Lanka. And the first step in doing so is to conduct a data impact assessment, a data protection impact assessment, as we would call it. A data protection legislation is not the only answer to it. There are various other mechanisms that are needed so that Sri Lanka will pass muster as a country to which data can be transferred. But I very firmly believe, and I know from practice as well, that having a data protection legislation is a very important and a crucial step in that direction. If we want to be considered in the international arena, especially in the EU, then yes, there is necessity for having a data protection legislation, and that data protection legislation to have these provisions through which we would be able to pass as a country that has sufficient safeguards for protecting of data of individuals. So that's the first step. But moving beyond GDPR, what the GDPR has done is it has sort of set the standards for many other jurisdictions to kind of follow. So we are not only talking about those in the EU or other countries who have adopted the GDPR, but also we are looking at legislations such as those in Brazil and to some extent even in China, where we are looking at the principles of the GDPR being applied. And for all of these, I would say that a data protection impact assessment is necessary. And again, having a data protection legislation is a crucial step in making sure that Sri Lanka can participate in international work, especially in the BPO sector and in the IT sector. And I think this legislation is undoubtedly a very, very crucial and an important step in that direction.
Thanks, Ashwini. Thank you for that. And with the interest of time, we'll just want to have a quick wrap up on the panel discussion. And I would like each of you to give you a 1 minute remark, just that. I want you to tell everything that you know in 1 minute. So the idea behind this is, what do you think will happen? What do you think will be the impact? What do you think will be the ideal outcome that you would expect out of the Data Protection Act? And what do you see as good and bad? Maybe 1 point each within a minute, if you can find a conversation. Maybe we'll start with putting you.
All right. So I think it's a good move for Sri Lanka, because if we can showcase, now we have to look at the export market. If we want to showcase that we have a good Data Protection Act, most of the companies, most of the outsiders know, okay, they know what we are talking about, they know how to safeguard information, they know what is privacy. There's a good chance that we can get a lot of business. That's number one. Number two, on the implementation front, there are a lot of challenges. Okay, if you are implementing data privacy, the Data Protection Act at your organization, start with the information security side, because the biggest part is how to safeguard the information that we collected. Second, the other part is more or less the governance side. We need to put all the practices in place, the breach notification, incident response, the data protection officer, all those things. Now, these things, what we talk about, comes with a lot of budgetary aspects. So we need to open the budgets for those things in terms of the resources, in terms of the technology, in terms of process. So that we need to be open about, right? And anyway, it's an act that we need to comply with. It's a good act, it's not a bad act, right? We need to comply with these things because it will move us to a particular direction that in the world, whoever who's come to get our services, they will think, okay, there are good laws and practices in place in the country so that they can give business to us. That is one on the business aspect. On personally, I really like we really can practice it, because like Mohan said, there are a lot of calls and messages that we are getting over the weekends or even over the weekdays, whether you like this, whether you want to have this and all that. That's a mess.
Thanks, Madhika. Over to you.
So I think just to wrap up everything, I have already mentioned earlier in my speech as well that this is a priority that needs to be taken up by all the organizations, especially when you have to ensure that the legal framework and the compliance policies are in place within the organization. And also there is something that I would like to mention, that this is, it was mentioned by one of the panelists earlier, I think it was Mr. Gui. He mentioned that this is not just one person's job. It's actually, it doesn't entirely depend on the compliance team. It doesn't entirely depend on the risk team, not the technology, not the legal, but it's a group effort. It's a team effort. The entire organization needs to come forward, and there are specific skills and knowledge that you need to put in place in order to make sure that you have a really good governance and compliance policy in place among the organization. And then there is also the knowledge aspect that you need to look into. You have to make the staff aware of the legal aspect, and also the qualification wise, there needs to be qualified professionals who are working in this area, which is going to be a niche market in the future. If you're looking at employment opportunities, that will be a really good opportunity for the risk and compliance professionals out there. And also, when it comes to the consumers, last but not least, that should be the organization's priority. You need to make the consumers aware of their rights, and to ensure that this is a step taken by the organization for the consumers. Because at the end of the day, the consumer is king for all organizations, and this is something for them. And also, last but not least, if we look at this from the country perspective, this is definitely going to bring in the much needed dollars that we are eagerly looking for, because this is going to be a value addition for our economy as a really good legal framework where the international companies can confidently invest in Sri Lanka, because we have a proper data protection mechanism. So now it is in the organization's hands to make sure that we implement it properly now that the law is in place.
Thanks, Arjun. Thank you very much. Ashwin, can we have some thoughts from you as well?
Thank you. Just to give a summary of my thoughts. As a starting point, I think there is really no more important resource today than data, and we need a legislation not only for its protection, but also to understand its use, how we can use it, and when, in what circumstances we can use it. It's immaterial to say that industries or organizations will have their own practices. We certainly need comprehensive legislation to do that. And that gap has been filled up by this legislation. So yes, undoubtedly it is laudable and the most important piece of legislation to have been passed in the country. That's on the side of why the legislation, but also in terms of challenges, I must mention that data protection, especially from an organization perspective, comes with compliance costs, especially for small and medium enterprises. So we need to see how, for small and medium enterprises, what kind of compliance can be brought in so that the businesses are also not disrupted and the compliance costs are also kept at a check, because the same level of compliance and the same level of resources cannot be allocated by all organizations. The scale in which they operate and the data which they use, the extent of data that they use are all material in that regard. So that's something that we need to keep in mind. And of course, as the other panelists mentioned, the implementation and the Data Protection Authority are what will really mean the success of the legislation. Thank you.